Yo, it's JP, October 13th, 2025, and I'm going to talk about the EEOC. As of today, as a result of the government shutdown, the EEOC is closed. What does that mean practically speaking? Well, it means that the public have no ability to file a charge of discrimination. The way the public portal works is you first are required to submit an inquiry, then the EEOC schedules you for an interview, then they assist you in filing your charge. And only then is your charge of discrimination filed, and only then are your rights protected. So, as a result of the current situation, there are many thousands of people out there in America who simply cannot file a charge with the EEOC because you can submit an inquiry, but nobody's responding, nobody's interviewing you, and your charge is never getting filed. And an inquiry with the EEOC does not protect and preserve your rights. You might be thinking to yourself, wow, this is some real fuckery. Like, this is unbelievable that this could happen, but this is America, okay? So read your history books, people. This is America. And in fact, when the Civil Rights Act of 1964 was passed, okay, when we got these different protections against workplace discrimination, the EEOC process was created as a compromise position, okay? You had a whole bunch of senators and congressmen up in arms saying, hey, you can't create a private right to file a lawsuit over workplace discrimination. There'll be too many cases in the courts. You can't possibly do that. And so the compromise was, okay, we're going to create the EEOC. We're going to make people go through this EEOC process, and hopefully a lot of folks won't do it, or they'll blow the deadline, and as a result, they'll lose their rights. And so at the end of the day, there won't be this avalanche of cases being filed, discrimination cases, right? So the EEOC was actually set up to be a rights stripping mechanism. It was not set up to help you, okay? It was set up to be a rights stripping mechanism and to be an obstacle that would prevent many people from actually getting to the point of filing a private lawsuit. So now we have this perfect storm with the EEOC being closed, where it is going to its ultimate intended destiny of preventing people from vindicating their rights because folks can't file an EEOC charge. So what are your options? Okay, let's talk about that. Okay, number one, get a lawyer. Okay, because as a lawyer who practices in this space, we have the ability via the EEOC's website to file a charge of discrimination at any time. I can pull up my laptop, I can go to the EEOC website, I can file a charge of discrimination, not just an inquiry. As a lawyer with a registered account on the EEOC's counsel portal, I can file a charge of discrimination for anyone at any time, okay? Every other lawyer in America should be able to do the same thing. All they have to do is register, get an account, they can file charges on the EEOC's website. So your best bet, hands down, is to get a lawyer, okay? And I've talked about this before. There are plenty of lawyers out there who charge people to prepare and file an EEOC charge for them. Our firm does not charge clients to file an EEOC charge. Why? Well, one, we are hyper selective about cases. We might take 5 out of every 100 cases that come across our desk. And so if it's one of those 5% of all cases we get that we accept, well, we believe in the case. We think it's a real case. We think it's a valuable case. And we're not going to charge a client. In many instances, this is a person who's either a poor person, a working person, somebody who just lost their job. We're not going to charge that person $400 or $500 to prepare a charge of discrimination. I have no interest in that. Okay. I'll get my money on the back end. If it's a plaintiff side discrimination case that I believe in, that I'm willing to accept, that I'm willing to pursue, then I'm comfortable investing the time and the resources on the front end and recouping that on the back end. So if you have a legitimate case, you should be able to find a lawyer who can, in short order, prepare and file a charge of discrimination on your behalf. That is, number one, your single best option. Number two, okay, depending on where the charge would be filed, you can go with the relevant state entity, but you need to be careful with that, okay? Here's why. In certain parts of the country, particularly in the South, all right, and this is where I have to go on a tangent and do a whole sidebar, okay? History and geography in America are still very powerful influences and factors in the legal system and in the legal process. The American South, the old Confederacy, remains in existence in more than just history and memory. There is a whole culture, there is a whole structure, there is a whole apparatus of the old Confederate South that is still alive and kicking today. It is anti-worker, it is anti-labor, it is anti-black, it is anti-poor people, okay? And the machinery of that system is still operating in many parts of the American South today. Florida is a great example, okay? Do not file a charge with the Florida Commission on Human Rights unless it is your absolute last possible option, because the state process in Florida is aggressively rights stripping, okay? You get jammed up in the Florida state administrative process, you might lose your claims, you might lose your ability to file a private lawsuit. Just don't do it. Don't mess with the Florida state administrative regime when it comes to employment discrimination cases. The same might hold true for other parts of the South as well. If you're in New York, if you're in New Jersey, if you're in California, you're in Illinois, okay, then by all means go through the state agency, the state counterpart, and file a charge there, and you should be fine. But proceed cautiously if you're going to do that in the southern states, okay? Because you may find that there are a bunch of gotchas and traps there that you're not quite prepared for, okay? Number three, if what we're talking about is race discrimination, then there is absolutely no requirement that you first proceed via the EEOC. Okay, and that applies regardless of what the person's race is. All right, whether you're black, whether you're white, whether you're Hispanic, whether you're Indian, regardless. Okay, if it is a race discrimination claim, you can pursue that claim via 42 USC 1981, the original Civil Rights Act from back right at the end of the Civil War. And that particular statute is far more advantageous than Title VII. Unlike Title VII, 42 USC 1981 does not include any caps on compensatory damages or any caps on punitive damages. So you are potentially able to recover millions of dollars between compensatory and punitive damages, with the only limit on that being the Supreme Court's 9-to-1 multiplier, talking about punitive damages being a maximum of 9 times the compensatory damage. So bottom line there, the EEOC is closed. You're not going to be able to file a charge of discrimination as a private individual. You need a lawyer to do that for you. The fact that the EEOC is closed does not pause any deadlines. I do not anticipate anything coming out of this administration or this EEOC that would toll those deadlines across the board, right? I don't expect any policy, any position statement, any rule, any announcement that could help you or that would be favorable to employees who are in this type of situation. So you have to take prompt action to protect your rights. Your best option, far and away, is to find a lawyer who can go on the EEOC's portal for lawyers and immediately file a charge of discrimination for you. If you have a real discrimination case, there is no reason why you should pay a lawyer to prepare a charge of discrimination for you. If it's a real case, you will be able to find a real qualified lawyer to take that case on a contingency fee. Jonathan Pollard, thanks for watching. Have a good day.